On 18 October 2024, Deputy Chief Justice Philomena Mwilu made a decision to constitute 3 judges bench comprising of Justice Eric Ogolla, Anthony Mrima, and Frida Mugambi to hearing the petition challenging the impeachment of former Deputy President Rigathi Gachagua.
The directions for the hearing of the applications before the court on the 22nd day of October 2024, in our view, lack basis. And they are.
Rigathi's lawyers, led by senior counsel Paul Muite, contested that DCJ have no power to constitute the bench. The mandate can only be performed by Chief Justice Martha Koome. The respondent side, led by senior counsel James Orengo, argued that there is no power vacancy. Hence, DCJ acted within the Constitution, given the fact that CJ by then was outside the country. What then transpired? Is DCJ Mwilu being haunted by her earlier sentiments? And after Court of Appeal ruling, does it mean that Deputy President Kithure Kindiki is illegally in the office?
Naibu Jaji Mkuu Philomena Mwilu sasa amejipata pabaya kwa kuwa baadhi ya Wakenya, mawakili na wachanganuzi wa masuala ya kikatiba na ya kisiasa wanadai sasa ni wakati mwafaka wake Philomena Mwilu kujiuzuru kwa kuwa alikiuka matakwa ya katiba ya Kenya. Haya yanajiri baada ya mahakama ya rufaa ikiongozwa na Justice Daniel Msinga, Mubigoge na Francis Toyot kuafikiana uamuzi kuwa naibu jaji mkuu Philomena Mwilu hakuwa na mamlaka ya kuteua jopo la majaji la kusikiza kesi zilizopinga kuondolewa kwake mamlakani naibu rais wa zamani Rigathi Gachagua, hivyo basi kubatilisha uamuzi ambao jopo hili ulifanya hapo awali. Nikirejelea chapisho kwenye Twitter kwenye akaunti yake Miguna amechapisha na kusema, what should Kenyans do to Mwilu if she usurped the constitutional power reserved for the CJ because she negligently interpreted the constitution? Na iwapo DCJ Philomena Mwilu alifahamu haya yote, basi ni kwa nini alitekeleza majukumu yake Chief Justice Martha Koome?
And the impeachment process that is ongoing regarding our Deputy President is not unique. It's an application of the Constitution. It's not something that has been plucked from the air. It has a constitutional process to follow, and therefore to that extent it is a constitutional process. The outcome of the Senate process, if it comes here, it's a case like the next case. It will be handled by we who sit in the judiciary in the manner the Constitution has authorized us to do, in the manner the law has authorized us to do. We can't go outside the Constitution. We can't go outside of the law. There's no risk of losing a document. You can't say, oh, my papers, I sent them to Nairobi last week and I have not had feedback. Technology is a game changer. After prudence, I would say technology is the other thing.
Ikiwa ni maneno yake naibu jaji mkuu Philomena Mwilu akiwa kwenye mahojiano na wanahabari ya iwapo idara ya mahakama iko tayari kutatua kesi ya kubaduliwa kwake Rigathi Gachagua. Kwa kurejelea maneno yake Mwilu, ni kwa nini basi jaji mkuu Martha Koome hakutekeleza jukumu lake la kuteua jopo la majaji hata ingawa alikuwa nje ya nchi? On this case, was technology not a game changer? Uamuzi huu wa mahakama ya rufaa bado unazidi kuleta msukumo mpya. Ningependa usikilize maneno yake Kibe Mwigai ambaye ni mmojawapo wa mawakili wanaowakilisha Gachagua kotini.
The Court of Appeal appreciated the fact that this is a matter that needs to be disposed of one way or the other. And that is why within 14 days, we expect that the Chief Justice will empanel a bench to rehear, fresh hearing of those applications. The significant point here before we lose it is that because there were orders in Kerugoya barring the swearing in of Deputy President Kindiki, it effectively means that you go back to the position as it was before the declaration was made. That is that there are orders barring Honorable Kindiki from being sworn into office. That is the basis upon which those applications will be had for our decisions to be made one way or the other. This brings to fore, is it therefore possible that the Deputy Chief Justice is in office lawfully? The answer from where we came from, because the courts have said severally, if you do something that you had no legal capacity to do, that thing is null and void. It is as if it never happened. And therefore, it is the position that as we speak today, and as a result of these decisions, the Deputy President may be in office de facto, that it is a reality, he is discharging certain functions. But under the law, he'll have to wait for the fresh hearing of those decisions to confirm whether he is in office. Because remember, immediately after that decision was made, what happened is that there was a ruling on 30th of October. The ruling of 30th of October, basically, I believe it could have been 31st, basically said that you set aside the orders that were given by the High Court in Kerugoya and gave the green light for Deputy President Kindiki to be sworn in. Now that we have reversed the position and gone to the position where there are orders, it is our position, and we shall be taking it to courts very soon as we have that bench, to be able to say that probably Kindiki, until the illegality of whether he's in office lawfully has been.
Na ili kuzidi kupokea taarifa za aina hii, kindly hit the subscribe button, notification bell, share and like. Hapa ni Nemo Media, kituo nambari 2 nyuma ya hakuna.